Copyright University of Auckland, all rights reserved. The content and delivery of lectures in this course are protected by copyright. Material belonging to others may have been used in these lectures and copied by and solely for the educational purposes of the university under license. You may record the lectures for the purposes of private study or research, but you may not sell, alter, or further reproduce or distribute any part of these lectures to any other person. Failure to comply with the terms of this warning may expose you to legal action for copyright infringement by the copyright owner and/or disciplinary action by the university.
Alright, we might as well get started in the interest of time. I'm Marie, this is Joy, we're the co-managers of the Outreach branch of the Equal Justice Project. Just wanted to thank you all so much for coming out tonight. We didn't anticipate that space was going to be such an issue, but that's really exciting. It's so great to see you all here. Thank you, of course, to all our speakers. It's amazing to have such a high-profile panel tonight, and we're really excited about what they have to say. Before I turn over to Joy, who's going to chair tonight, just talk a little bit about EJP, just for those who haven't heard about us before. So EJP is a student-run, not-for-profit organisation. We empower communities to seek equal justice. There are over 160 volunteers this year, which is the biggest intake we've ever had. There's 5 different teams, of which we are the Outreach branch, as I mentioned before. So our goal is to raise awareness and discussion around topical legal issues. So tonight we're going to be live tweeting the symposium through @EJP_NZ, and there is a hashtag which will come up on the slides so you can all follow along. If time permits, we will open up to the audience for questions, so bear that in mind. And if you haven't heard enough about EJP already, there are sign-up forms floating around the room somewhere for the mailing list.
Thank you, Marie. Miscarriages of justice. It's a penalising word for our justice system. The exact opposite of what we want it to achieve. What do you think about when you hear this term? Is it David Bain, freed after 13 years in prison? Is it Teina Pora, deprived of 21 years of his life for a horrendous crime he did not commit? Yet these cases stand in sharp contrast to Mark Lundy. 14 years in prison, but for the second time convicted. Many hailed this case as a case of justice done and seen to be done. But given the Pora and Bain cases, can we really be sure that we can't be wrong for the second time? It is precisely the Pora case where a second jury convicted him in 2000. We have to keep in mind that whenever there's a miscarriage, there are 2 injustices. When we put the wrong person in prison, another takes the freedom without the responsibility. Bain and Pora may represent the tip of the iceberg. High Court Justice Sir Thomas Thorpe estimated that there was likely to be 20 innocent people in prison at any one time. Why do we have miscarriages? Is it the inevitable consequence of holding people to account? Or are we just desperate to find a culprit at any cost? We will examine 2 key issues today. The first is what is going wrong in the prosecution, the conviction, the trial, and the appeal processes, and secondly, and more importantly, what can we do to address them? It is my pleasure to introduce our high-profile panel tonight. Jacinda Ardern, Auckland Central MP, key Labour Justice Spokesperson and a key advocate of a Criminal Cases Review Commission. We have Marie Dyhrberg QC. Marie was the past chair of the Criminal Law Committee of the International Bar Association and was the first woman to take on this role. She is the present Commissioner of the Auckland District Law Society Criminal Law Committee. Marie was also the defence counsel of Pora at both of his trials. Julianne Kincade. Julianne, a criminal barrister, was a senior solicitor and associate at Meredith Connell from 2007 until 2013. She now has joined various chambers as a defence barrister. Julianne was one of 3 defence counsel at the Lundy retrial. John Buttle at the end. John Buttle is a senior criminology lecturer. Just checking he's actually at the end. John specialises in criminology and criminal justice. John has written reports for the New Zealand Police as well as the Ministry of Justice. Peter Jenkins. Peter has been with the Sensible Sentencing Trust since its inception in 2001. He is the website manager, trustee and co-manager of the offender database. We'll now launch into the opening question of our symposium. This symposium will follow a question and answer panel format, with me asking questions and the panel getting 5 minutes to respond to each question. So we'll start off with the question. Sorry, missed that. We'll start off with the question, and each speaker will have 3 minutes to respond. What do you think is wrong with the criminal justice system? What are your views on the 3 cases? And what is the public perception on the justice system today? We'll start off with you, Julianne.
Thank you very much, all of you, for coming tonight, and thank you for inviting me. That's obviously a huge question, which is hard to answer in any time at all. Could spend a long day, thank you. Perhaps with looking at these 3 particular cases and trying to draw some conclusions from looking at them, of course there are lots of differences between them, but one of the things they have obviously in common is that they all had to go to London in order to gain relief through the appellate process, and although there were various paths that each of them took, they all ended up in London. And that is something which we certainly need to keep under review as to whether the appellate process in this country, in such a small country, works properly. Each of those cases also, as you know, had a white knight, that a person, an individual who took up the cause on their behalf and without whom their cases would never have reached the Privy Council. Those people worked obsessively, some might say, tirelessly certainly, and suffered within their personal lives in order to take on the cause of people that they hadn't met before their convictions, but solely for the reason that they believed the convictions were wrong. And in each of those 3 cases, their conviction on that point was proved to be correct at the Privy Council. The other, perhaps a smaller point to observe on those 3 cases is that each of those people were interviewed without lawyers. And I say that to you, a room full of people who I imagine are lawyers, and some of you will go on to be criminal lawyers. With Teina Pora, of course, he's a little bit different. He had a past with the police and some experience of the police, but it has now been well catalogued. There were other reasons why he obviously should have had someone present with him through that interview process. Whereas Mr. Bain and Mr. Lundy were both people who had never had any experience before of the criminal justice system, and yet in investigating such serious crimes, the most serious crimes of our criminal justice system, the police thought it was, and the court system think it's appropriate for them to allow to be interviewed without having a lawyer with them. I say that particularly in the case of Mr. Lundy. He was interviewed at some length on the 23rd of February 2001, the day he was arrested, still believing that he's assisting the police, and the interview starts off in that way, but that officer knew that at the end of it he was going to be charging him with a double homicide. And I question whether that in fact is appropriate and a fair approach in order, and certainly coming from England, I would say there would be big question marks over that, and it would lead to the possibility in certain circumstances of being able to make an application to the court to have the interview excluded, and that doesn't seem to happen here so much in New Zealand. I think I see the 2-minute signs coming up, and I know there's lots of other questions, so I think I'll probably stop there for the moment. Thank you. Yeah, thanks.
Good, thank you. I was the counsel in both the Teina Pora trials, so I have consulted with his lawyers at the moment about what I'm going to speak about tonight, so I will turn specifically to Teina's case later. But what have we learned from the 3 cases? Now, obviously, criminal trials are going to deal with humans. You know, there are people who are scientists, there are people who are judges, there are people who are juries. So that is the arena in which we are working. So one has to say, look, there are going to be some problems, there are going to be some miscarriages of justice. How do we minimise the numbers of those happening? What do we do to make available what we can do if there is any suggestion that there is a miscarriage of justice? How do we get that independently reviewed? Because miscarriages are on all levels. We set the case law and the precedents by these cases, these major cases, but for someone to be wrongfully convicted, and we've seen them, we've seen people wrongly convicted, it eats away, it destroys their lives. And you've all seen the recent program, television programs with those people. Some of them were convicted on relatively small matters, but they never got over it. So we have to say, what do we do? Because increasingly we deal with issues such as scientific evidence, identification, circumstantial evidence. Now, that seems to be something that the judges seem to put a lot of weight on, circumstantial. There's no such thing as coincidences, whereas in real life there are. Stranger things happen. And you just have to hope that there's someone on a jury who has had that strange coincidence happening. And you see, for someone like Teina Pora, we have a system here in New Zealand. He's, as I say, he spent 21 years inside. All Teina wanted was to get parole, to get free, and then work on his case to show that he was innocent. Well, of course, he maintained his innocence. And those of us who deal in the system, if you maintain your innocence, you are prevented from taking courses that are essential for you to be considered safe to go back into the community. If you don't do those courses, you're not going to get released. But unless you admit your guilt, unless you accept you are wrong, then you're never going to get out. And this happened time and time again. I went to a number of parole hearings with Teina. We had experts, and we actually had, who shall remain nameless, senior judge. He said, but can't he just say yes, Miss Dyhrberg, and then, you know, come back? And then he went, did I really say that? Well, he did, because that's the frustration we felt, is that it's just catch-22. So I've had the 2 minutes, and there's others who want to do this. But it does come down to, we will keep coming back to the theme. It comes down to resources, it comes down to funding, it comes down to money. Now, for those of you who watch The Good Wife, we would all love Jacinda. She's a crook, she's everything. Nobody has the money for that. You do not have those people. You have to justify why you want experts. You can't just say, I just want to go fishing. I just want to poke and prod, and I just want to have a bit of a look here. And we've got Dr. Anna Sandiford here tonight. Prior to her being available to Defence Counsel, we had no one. We could not get defence scientists. We had to go overseas. We were turned down every which way we turned. We just couldn't get the money. Thank you.
Yeah, hi. I'm primarily in my role as Assistant Manager of the Sensible Sentencing Trust Offender Database. And there's a few of these cases actually did come up. The Lundy one in particular, I remember when the Lundy case came up, and I looked at the original Crown case and I thought, my God, if Lundy did actually manage to drive from Petone to Palmerston North and back in the time alleged by the Crown, then he was in the wrong job. He should have been driving for a racing team. But yeah. Yeah, so there were the original Crown case had many flaws, and I think this is the case when we have complicated, difficult cases like Lundy, like Pora, and particularly Bain was an extremely complex case. This is where the system does seem to be most fallible. And certainly, the Sensible Sentencing Trust wants longer sentences for guilty people who really are guilty. We don't want them for people who are innocent. That there's a huge injustice. So this is a really important point. If we can have longer sentences, the people have got to be genuinely guilty. Otherwise, it's just wrong to put them away. And I can imagine, I deal quite often with victims of crime who are feeling powerless, distraught, their world's fallen apart, and they feel totally powerless and at a loss as to what to do. And I should imagine that the experience must be very similar for someone who's facing allegations or accusations of having committed a crime when they are innocent. The experience would not be dissimilar because you'd feel that same powerlessness, that same hopelessness, not knowing what to do or where to go. In some ways there is a similarity there. The Lundy case is the one which I'm most au fait with, and there were numerous holes in the original Crown case. On that basis, a few weeks after his original conviction, I actually withdrew Lundy from the Sensible Sentencing Trust's offender database because I felt that we just could not in all conscience keep him on there. That case was too flawed. Bain, we've never put him on because right from the start we just did not feel that he'd been convicted beyond reasonable doubt. And that's the key thing, beyond reasonable doubt. There were reasonable doubts in the Bain case, right from the word go. Pora, we were not aware of the problems with that case until a much later stage. When it went to appeal, we pulled him off and we won't be putting him back on. There are a number of others too who we have either not put on or withdrawn over the years. The most prominent of which is Peter Ellis, who I think is perhaps the gold standard case of an unjust conviction in New Zealand. Many of you remember the Christchurch creche case, about which Linley Hood wrote the very good book, A City Possessed. He will never be in our database. We're in general agreement that the guy, if not innocent, is certainly nowhere near his guilt as ever been proven to any reasonable standard. Scott Watson, we had him on, and there was a number of people agitating for him to be removed, and we felt they may well have a reasonable argument, and we would like to see that case go to a public inquiry or an appeal because it does need to be resolved to the public's satisfaction. That's really important. There needs to be public confidence in the justice system, and cases of unjust conviction like this erode that confidence. And so we applaud their Equal Justice Project, just as we do the Innocence Projects overseas, as a necessary part of the process, increasing confidence in the justice system. Thank you.
Thanks, Peter. That was an useful, I think, contribution, because absolutely it does erode public confidence when we have miscarriages of justice. But I think you've also highlighted why public databases can be problematic, but I'm sure we could have a larger debate about that another time. Forgive me in advance, I might go slightly over my time. I'm unable to stay for all of the panels, so I wanted to just get out a few thoughts in particular on the Independent Criminal Case Review Commission idea. But before I do, I really wanted to reiterate something that really Marie touched upon, the idea that when in New Zealand we talk about miscarriages of justice, we do tend to think and reflect on quite high-profile cases, when actually, by default, the definition of a miscarriage of justice is a failure of a court or judicial system to attain the ends of justice. So when you're thinking about that notion in broader terms, then is it a sound justice system, therefore, is one that is accessible, one that is fair, and one that is timely? And under those criteria, there are lots of issues that we should be looking at more broadly when we think about miscarriages of justice. For instance, is a sound, accessible justice system one where to access legal aid, you essentially have to, as an independent single person, earn less than minimum wage. Is that a fair and sound justice system? Is it an accessible justice system where you have an increase in self-representation, not out of choice, but out of necessity for an individual? Is it a fair justice system, one that puts cost at the heart of a decision around prosecution, causing an increase in plea bargaining? Is it a sound and fair justice system, one that produces different outcomes based on the region that you live in? And I'd have to say, if you're a young Māori male before the courts in Christchurch, that's a very unfortunate position to be in relative to other parts of the country. And is that accessible and fair? Is it accessible, fair and timely when you have a potential miscarriage of justice and your option to redress that is to write a letter to the Governor-General? Because that's essentially what we have in New Zealand right now. And that's where the notion of whether or not we should look at an appeals process is the area that I think has flaws in it in New Zealand because of that element of the royal prerogative of mercy. And so I think it is worth looking at what has happened overseas, where they've looked at alternatives. And I wanted to quickly compare what we have in New Zealand now to what, for instance, they have in the UK. So in New Zealand currently, the authority to exercise the royal prerogative of mercy is delegated to the Governor-General. The reality is somewhat different though, and I used to work in Phil Goff's office, and I saw firsthand there the number of times that you would get letters trying to access that appeals process. Essentially, in order not to politicise that process, it really was a delegated authority to the Ministry of Justice. So that's where the Governor-General gets advice from the Minister via the Ministry. Those Ministry of Justice advisors have limitations. There is no power by those advisors to gather extra information. It's all done on papers. Most often, simply, they will gather the court file, and only on some instances will they seek the police file. That does mean that there is a natural advantage to those who are well resourced to present a very solid application. Again, those who have the white knight who are assisting them have a bit more of an advantage over anyone else, and no justice system should be reliant on that. There is no dedicated unit within the Ministry of Justice who deal with these applications. So they don't have access to particular expert advice. And on occasions where they have used external advice from QCs, there has been some evidence that what advice the Ministry has received from QCs is different to what advice they then put to the Minister of Justice. Compare that then to what they have in the UK, where they have brought in an independent criminal case review commission. Similar to New Zealand, you have to exhausted your appeals process to make this application, but the real difference is the way the review process then happens. Unlike in New Zealand, an independent criminal case review commission can access external expertise, not just legal expertise. They can call on specialist advice that might be relevant to the case. They have statutory powers to require disclosure, and they aren't confined to just looking at the points raised in the application for review. So if they look through an application and find, and we're looking for a file, actually find that they see procedural issues, they can explore those procedural issues. And in fact, in 15% of the referrals, where they make a recommendation for a case to be reheard, it's on an issue that wasn't even raised in the original application, which is really interesting. And most importantly, the Independent Criminal Case Review Commission in England represents no one. It doesn't sit there for the Ministry of Justice, it doesn't sit there for the Minister, it exists solely to uphold justice. I guess I would just conclude by saying it's not a perfect system. There are innocence projects who have raised concerns over even the Independent Criminal Case Review Commission, but it is a damn sight better than what we have now. And when I asked someone who worked on Teina Pora's case what difference it would have made to them, they said probably about 5 years. So on my mind, it's a step absolutely in the right direction.
I pretty much agree with just about everything that's been said there to some extent, and now I'm left with what's left over. One of the things that nobody's mentioned here, actually, everyone seems to be focusing on the courtroom processes and so on and so forth. That's good, it's important, but you've got to remember that in all of these cases, it was the gatekeepers of the criminal justice system that started things rolling. That's when things started to go wrong. So I'm talking about the police here. Yeah. Now, when some massive crime occurs, it hits the newspaper, there's a massive moral panic, and you have a hell of a lot of people ranting, raving, wanting justice, which then hits the political level, which then hits the top cop, which then hits the guy in charge of the investigation, and so on and so forth. So there's a lot of pressure on police officers to actually bring someone in. Now, if you look at if you think about the way that investigations actually occur, if you look at the stats for the police on their own website, you will find that their resolution of cases is under 50%. So, you know, less of a chance really than flicking a coin as to whether you're going to get a result. Now, most of that is around things like burglary. Okay, when it comes to actually homicides, the police are usually quite good at finding someone. I've got to be very careful what I say there. At finding someone. Quite often, when someone's committed a murder, the first thing they do when they get caught is actually just go, "Oh, you know what? It was me." Yeah, there's a rather tragic case of a man in America today, actually, who went to the police station himself and said, "I just killed my best mate. It was the drugs." Okay? So a lot of the time, the police, it's quite easy for the police to actually get a result in this way. The other thing that occurs is the police tend to get a result when there are good, credible witnesses. Okay? So they tend to get a conviction from that. When it comes to the circumstantial evidence, as people were saying, not so much. It's even the case that some police officers will arrest someone, and that someone will have a DNA hit, but they won't bother to look for that, so they'll then send them off after the fact that, you know, not even knowing they've got a DNA hit for another crime. So it's not a foolproof system. The other problem is, of course, the pressure. You have a number of police officers here, you can see in these 3 cases, that have at the very least been very incompetent, and on the other hand, I think the report says about a police focus. Well, there's another word for that. It's called fitting someone up. Yeah? That's a different word, isn't it? Beginning to feel that one? Good. And you can see in certain cases, particularly the Bain case, where certain things to do with the actual mens rea, the reason why Bain was supposed to do this, were kind of withheld. Yeah? Which would make you actually I think any jury would actually think, you know what, I don't think this was young David Bain. I think it might have been his dad that did this, you know? So if you want to deal with this problem of miscarriages of justice, and you can do it after or before, then the police that have actually been involved in these cases actually need to be held accountable, yeah? And they actually shouldn't really be doing that job if that's the way they go about doing things. Is my 2 minutes up? 1 minute. I'm going to quickly say just one thing real quickly, and that's about the Privy Council. The Privy Council is kind of important, and it's important because this is where you can pick up this case and take it out of New Zealand and put it into another culture. A culture that really doesn't care about the legitimacy of the New Zealand courts. Yeah, so it removes that bias, or claims against that bias. It also doesn't care about the views of the general public in New Zealand. All it does is it looks at the evidence, yeah, and it weighs it up as to whether this is a safe conviction or no. And I think that is very important, because that in itself is independent. Yeah, it's outside of our culture. Now, when I talk about David Bain, okay? I bring it up every year in class. And just about every time I mention that, one of my students, or probably usually about 5 of my students, go, yeah, I think he was guilty. Yeah? And that's the reason why it's kind of important to have some situation where you can lift this thing out of your culture and put it into someone else's. Yeah, don't get me wrong, the British are just the same. If they're talking about their own their own criminal justice system, they will defend it to the hilt, and you know, they were never wrong. But the beautiful thing is they've got the European Court of Human Rights where that can be overturned. They don't care about the British system. Do you see what I mean? So this Privy Council thing is a very, very important thing for us in that way, in getting clearer and I think more fairer results.
Thank you so much, speakers. Jacinda, I'd just like to say thank you so much for coming today. I know you do have to leave soon for another commitment, but we really appreciate your time. Thank you for adding so much insight into the discussion. We will now launch into the first question concerning the police and prosecution process of the justice system. John, you obviously have a lot of foresight and you answer this question very well already. So I'm going to ask this question to the speakers. You mentioned that there was a lot of inadequacies in police conduct in the Bain case. For example, the house was prematurely burnt down, along with a lot of key evidence that was crucial to the defence case. Now, do you think that police not following conduct is a result of preconceived notions of guilt, so, for example, tunnel vision, or do you think it's a result of wider systemic issues in the justice system, such as a pressure to find the right culprit?
I think it's kind of both. There's going to be pressure to find the right culprit, and that means that you're going to push for something that a person that you think is in the frame or whatever. Yeah. If someone hasn't come forward and said it was me, or they haven't just admitted to it, and you got no witnesses, as an investigator, you're really in trouble. Yeah, because all you've got are suppositions that can be made off the back of sometimes good science, sometimes some pretty shonky science, and a lot of times some shonky science. And at the end of the day, if you're a police officer and you're going to narrow things down to the extent that you're going to avoid giving the defence certain information about other motives for happening, then that is actually, you're not being a good police officer when you do that. And to my mind, that's pretty much out there with that should be punishable itself, I think.
So, full disclosure, my father was a police officer for 40 years. 40 years, that's such a long time. He spent 14 of those years in the CIB as a detective in Hamilton, dealing with some heinous crimes. Mostly kept that really away from my family, but I remember the odd holiday being cut short to come home so Dad could investigate a murder, or getting up late at night and seeing him pore over evidence on the dining room table. He himself would admit that there are some really good police officers who are there for all the right reasons, and then there are others who are not so good. Every profession has that. I think the question for me is, how do we try and make sure we upskill that workforce so that they can do the best job possible? And how do we deal with the consequences when a poor job, in fact, a patently wrong job has been done? I don't think we spend much time talking about the latter. I do think that the police force is a quite tight-knit family, and so if things go wrong, they tend to act in quite an embattled way. They tend to protect one another and close ranks. I do think that there's a psychological effect there that happens. Politicians do it too. The IPCA is a critical force in all of this. And I do think they are increasingly playing an important role in ensuring that not only are the police held to account, but that we change the way they behave when we learn where errors have occurred. I'm not sure, though, that their findings, whilst they might try and change things systemically, really translate into individual accountability. And in these cases, that's actually what needs to happen. In the Teina Pora case, there should be an IPCA report on what happened in that case. You watched those interviews, it was wrong. So I do think we need to ask the question about individual accountability.
Thanks so much. Sorry, in the interest of time, we're just going to move on to the next question. I do promise you have your turn very soon, John. Now, John and Jacinda both mentioned that police or the prosecution may actually withhold key evidence or perhaps disclose key evidence late to the defence. An example of that is when Pora was going through his first trial, the police actually suspected that a serial rapist killed and raped Susan Burdett. DNA tests were already underway at that point, but before the results were concluded, the trial still went ahead. Now, this key fact is crucial to the defence case, and it was not relayed to the defence. And so the jury convicted without knowing this key information. So my next question is directed at Gillian and Marie. What effect, generally, does late disclosure and withholding evidence have on the defence ability to counter the prosecution case?
Oh, very good. There's late disclosure, Helen. I see you there, and Helen does a lot of high-profile cases when we get dumped with something at the last minute and we are already working 12, 14 hours a day. It is horrendous. There's no question about it. It is just terrible because you need time to reflect. It's one thing to have information. You need to be able to reflect and say, what does that mean? Where do I go with this? Who do I find? How do I go about, testing? As I say, we've already referred to Dr. Anna Sanderford, and we've also got Amira here, Amira Nagumi, who's a scene of crimes expert. We didn't have those people of recent times. We don't know what we're looking for unless and until you have everything. Now, this whole serial rapist theory for Teina Pora, as I say, it just simply wasn't available, wasn't given to us. There's other information that wasn't given to us that my lips are sealed, but I was accused of, she's got a deep throat. Who's feeding her this information? As I would go back and say, may I please have? I was also had deep throat coming back. God, they're just beside themselves what you're asking for. But if I didn't have that person, a lot of material would not have come to us. And it is just totally unjust. It is not for the police. Good police officers will give you everything. They say, have it all. You have it, not a problem. And it comes back to, again, who you're dealing with. For example, all police officers, investigators, they are either clever, they're not so clever, they're bright, they're not so bright, they're open-minded, they're thick as a plank, all of those sorts of things. They're just like some lawyers, unfortunately. And there we go. And I just look at the Kahui trial, and I've dealt with John Timms, who's very, very senior police officer. And so I acted for Maxine King. She would have got convicted on prejudice alone had she gone to trial. And when the investigation first started and John Timms was in charge, I wagged my finger at him and said, you take your time, remember Michael Letafunga. And he was a young cop, interviewing cop in those days. And the police decided it was Michael Letafunga who had committed the homicide of a 15-year-old. Blinkered, that was it. That's where they went. And all their questions for weeks was, do you know Michael Letafunga? Did you see him on the night? And away it went. I won't go into details. It makes a great story. By a fluke, the 3 random killers who killed this boy randomly by mistake went, oh, you want to find out about the knife? Yeah. Good. And even then the police were still saying Michael's involved. And John Timms took 18 weeks before he made an arrest. And he would not be bullied or pressured, even though the Prime Minister got on the wagon, Paul Holmes got in, everybody got in, and he resisted. But we aren't always that lucky. And that's what we're dealing with. The IPCA at the moment has Sir David Carruthers. I can't speak highly enough of him. He is trying for independence. He is trying to get non-police people do the investigation. He wants powers that the IPCA can prosecute, can bring their own cases. We have those people. It's horrendous not to have the information.
It is. I don't know if everyone in this room knows that on the 21st of January, we were told, with the trial starting in 2.5 weeks, starting on the 9th of February this year, we were told that the Crown's time of death had changed to post-midnight. Now, when we said that in court to the jury, they were shocked, but afterwards I thought, they don't actually know what that means. What that means is all of a sudden we don't need 3 or 4 experts who we've been briefing and had to get legal aid for, and how long that takes. Don't even start me on that topic. All of a sudden now we need to switch the focus, and we need to get different experts involved and different emphasis on particular parts of the evidence. That was within a context of there having been court order after court order about disclosure, and the Crown finishing their testing in July and August of 2014. It carried on and carried on and carried on. We got some results on Christmas Eve, which meant everybody was working on Christmas Day. Ho, ho, ho. And, and that's the sort of thing it means in reality. And it's not... I feel very strongly that it's not unless and until the Crown, the courts say to the Crown, and I speak as you've heard as an ex-prosecutor, you can't have that evidence. It's too late. I'm not going to admit it. The jury are not going to hear about it. Unless and until that happens, this will carry on. And it's interesting, isn't it? It features in all of the case. Joe Karam called one of his books Trial by Ambush. It's not right. It's absolutely wrong. I can't believe they only decided on the 21st of January about the time of death in our case. I just can't find it hard to believe. Anywho, one of the great, to be more positive, one of the great things that has happened is the Criminal Disclosure Act. And one of the good things that happened in the Lundy trial was that early on we asked the prosecution to volunteer themselves into the system, and they did that, and that was brilliant. We ended up with a disclosure schedule over 500 pages, thousands and thousands and thousands of things. Most important things obviously coming in those weeks leading up to trial. But it's a great thing, the disclosure schedule. And also, not only did we have it, but it was searchable. So in this modern era, we have something so you can do your Control F, search for a name, search for things. And when you've got over 500 pages and thousands of items, that's invaluable. The police were able to hyperlink their disclosure schedule into the actual disclosure, which unfortunately I never managed to do that. But I had a good handle on everything and where it all was, and I had Dr. Sandiford to help, and also Mr. Tim McKinnell. So we managed, but that would have been even better. And I think if in the future there should be good cooperation about the availability of technology and equal access to technological advances, and being able to access, not only have the material physically, but be able to electronically search, and especially in the big cases, that's really important. Thank you. I see the sign, so.
Thank you so much. We'll now move on to consider the trial and the conviction process. What is going wrong there? What do we need to fix in that process? I'll start off with asking, there are allegations that some witnesses that stood for trial, especially for the Crown in the 3 cases, were unreliable. For example, a jail informant was allowed to stand at trial and give a testimony against Lundy. Do you agree that they were in fact unreliable witnesses? And what impact does that have on the fairness of the trial? Should there be tighter rules to restrict the type of witnesses that can appear in court? I'll leave this open to anyone who wants to answer. you, John.
Well, a couple. Can I just talk about the last question first, and I'll quickly pop into the second,
absolutely.
because I can talk forever. Sorry. In the Pora case, one of the problems was that the young man had some cognitive deficits. If you go to the death row in the US and you have a look, there's a considerable number of people there with IQs that are around about the 80, so that makes them in the special needs category, or whatever is the PC word for that now. Now, the point I'm trying to make here is that if you're going to interview people that have these cognitive deficits, they're going to be very, very easily pressured into turning around and saying, yes, it was me. Okay? So maybe we probably need to have some way of monitoring interviews. I think, having cameras and monitoring every interview or interaction in that little room with the police and the suspect would be a very good thing. It would give us evidence to look at afterwards. I also think it would allow us to study this to see whether interviews can be conducted in a way that don't become too coercive in that way. In regards to the second question, which is witnesses, there's a lot of research out there that suggests even eyewitnesses can very, very easily pick the wrong person. If you look at the classic studies by Loftus, if you're interested, just Google her. She's pretty much spent a career walking around saying, well, yeah, you picked this person out of a lineup, but the reason why you picked this person out of the lineup is because they look amazingly like your university lecturer. Yeah? So even when you have got a witness that turns around and says, yes, it was him, I saw it, it's bright as day, it doesn't necessarily mean that that witness is right or correct.
If I could just talk about witnesses, we always love the story in the High Court, and a complainant, a prostitute, was asked to pick out the assailant in the courtroom. Can you see your assailant? Who raped you? And Kay wrote, yes, I can. She's very modest. And Aaron Perkins said, you have to pick him out. Okay, and she kept her head down and she came round and round and round. That's him. And so for the record, Aaron said, let the record reflect, witness has identified New Zealand Herald reporter. And Aaron did it with a straight face. It was wonderful, it was just, but there it goes. And we call these terrible witnesses, these jailhouse snitches. They are people who have something to gain. So that doesn't automatically mean they're going to lie, but one always has to say, this person has lied to their family, they've lied to their spouses, they've lied to their best friends, they've lied to everyone for months and months. And then all of a sudden, out comes a complete stranger who shoves some food, through into the cell. Fair cop gov, let me tell you everything. It is just a nonsense for a start. You had in David Tamahiri case, 3 different jailhouse snitches, all telling 3 different stories, none of which matched up to where they found the body and finding the watch. That is a miscarriage of justice, as David Tamahiri, as with Scott Watson as well. Now the problem is, you could say, okay, they're entitled to give their evidence, but you try and get their prison files, you try and get what sort of benefits they've got. Did they get compassionate leave? Did they get a new job? Did they go from being a cleaner to working in the kitchen? Kitchen rules. You get to eat. It's warm in the winter. It's fantastic. Did they get a declassification so that their security went down? You can't get that information. This issue arose in the Pora trial. And in the end, the Crown said, well, the window of opportunity for Mr. Pora to tell this person something was about, a fraction of a millimetre. It was just not there. We still did not get that information. In Australia, you do. You have no problem. Just go to the DPV, you say, I want all this information. It's all there. And I had a prison officer in a case where I sort of was running, somebody had set up another prison officer for drugs. And I said, but your main evidence can't came from, and I named someone. He just about fell on the floor. Lots of deep throats that along the way. And the prison officer said with a straight face, no, they don't get benefits. People come forward. Prison inmates come forward because it's the right thing to do. You know, and this person, I had a list of things because I ended up with a fire slipped in my door at 4 o'clock in the morning, I think, one morning, lots of dark. They cannot be trusted. In Teina Pora, the members of his family were paid to testify. Now, you can cross-examine these witnesses during the trial. They say, we haven't received anything. We had lots of Kentucky Fried, but no money. They got the brown envelope after they left court. That's when they got the cash. There were no job sheets, there were no notebook entries, no records of those payments. In total for Teina, those family witnesses, those loving family witnesses, were paid approximately $15,000. That's a lot. And one of his aunties persisted in a claim that he was involved based on the dreams and visions she had. Well, it's just outrageous. And then in the retrial, along comes another family member who wasn't in the first lot, who wanted the money, and she sort of made a connection between Teina Pora and Malcolm Rewa. In my view, those confessions almost inevitably flawed. There should be at least voir dire, and the full record should be open, and anything later that's given to those witnesses should be given to defence, so you can go back and say, hey, appeal court, let's have another go. Very strongly, I feel.
Sorry,
I'd really like to make one point on that, an important point, sorry, that feels very strongly on it too. I just want to say this, that having practiced in England for 13 years, I didn't have one case, I didn't even hear of a case where you had this type of evidence, and I'm sure that somebody will dig out one. I'm just saying that I'm amazed in New Zealand that in every single high-profile trial, oh look, here's another one. Somebody who, people who have maintained their innocence for years and years and years suddenly pipe up to a complete stranger they bump into in an exercise yard, say something which is actually rubbish and doesn't even fit with the timing of the events, talks about their appeal and they haven't even been convicted, and that evidence is before the jury. If that's appropriate, if that really is the best evidence that can be called by the police, I think they really need to be examining the case as a whole. And what happens later, as in the Scott Watson case, when that person says, well, it was a lie, actually, because I did it for these reasons. What happens to the conviction? I think it leaves the whole system in a sort of quandary, because are the Court of Appeal going to say, oh, well, the jury didn't pay much attention to that person, look at all the other evidence. Well, if that's the case, then why are they there at all? It's not evidence, and I don't think it should be before the jury unless there are quite exceptional circumstances. And I think people need to ask about the fact that these witnesses appear in all of these large cases in New Zealand. It's very strange.
I'm glad you made that point. Thank you, Julianne. Moving on. Obviously, it is the jury that has to decide this sometimes weak, ambiguous evidence. I now turn to the question, and I'll pose this to you, Peter. As a lay member of the community, do you think it's realistic that juries will actually assess all this ambiguous, conflicting evidence from an objective standpoint? What effect does the high level of pre-trial reporting in the media, in the digital age, have on the jury's decision-making process? Do you think they actually make up their minds before the trial even begins?
I wouldn't say so. I've been on a jury, and we did examine the evidence. But it comes down to full disclosure. If you're going to use one of these jailhouse witnesses, as Marie's just said, we need to disclose what benefits they're receiving for giving their evidence. We need to disclose their full record. The jury needs to have all the information. The more information a jury has, the better the decision they'll make, hopefully. Certainly, withholding information from a jury does not make for a better decision process.
What about the information in the media? For example, before the Bain trial had even begun, the media essentially convicted him, saying Paperboy killed his family. You know, do you think that forms a preconceived notion of guilt in the jury's minds?
I think it could be, but I think all juries are also directed to specifically ignore stuff information that comes in from outside like that. And I think juries do take the responsibility seriously, generally, not always. There have been some cases where it's been noted they haven't. It is a difficult one. I think perhaps also the way in which we pick juries in New Zealand needs to be looked at, because often people are picked who don't really want to be there, who are not really suited to that jury process. And there's something to be said for the possible idea of having professional jurors who actually have put their hands up for the thing, have some training, and have the sort of analytical mind that you really need to be analysing evidence in complex cases like this. So I think that's something else you could examine that may improve the jury process and the justice process as a whole as a result. Juries will ask the question, could Lundy really drive from Petone to Palmerston North and back in that time, and would have questioned the original conviction? Juries should ask questions like that. Certainly when I was on a case, we had a couple of questions to ask. Fortunately, it was a fairly clear-cut case where the accused themselves kind of made it kind of obvious that they had actually committed the crime. In some cases, in a lot of cases, this is where the police fall over, I think, in a lot of cases, the conviction is fairly easy to get. But when you got complex cases like the Bain case, like the Pora case, they struggle because it's of a much greater depth of complexity than they normally used to dealing with on a routine basis. And I think, with complex cases of this nature that are, difficult cases, perhaps we need to pick a better quality of juror. There could be something to be said for that.
Obviously, the difficulty also comes in when they have to assess complex scientific evidence. I mean, are they really capable of assessing objectively highly complex scientific evidence that scientists hasn't even agreed on? So I think that's a good point. If we move on to the next question, and this is about the appeal process. Jacinda and Julianne, you also mentioned before that these cases are really pulled through the system because of certain champions who are willing to stand up for them. For example, Tim McKinnell, private investigator, who was willing to give up thousands of hours of his own time to support Pora in collecting all his evidence. Going back to the question and the issues that Jacinda raised, do you think there should be more systems in place to increase the resources available to the defence, given the disproportionate amount of resources available, both in terms of personnel, expertise and money, between the Crown and the defence? I'll leave this open to the panel.
Certainly I think you'll find that unless somebody can privately fund an appeal, nobody is doing appeals on legal aid, and I'm not going to put Helen on the spot, and does a lot of work. Shindy's up there, does a lot of work with me. You just can't afford to do appeals on legal aid. You have to persuade legal services that you have a case first. Now you come to a case, you've got to do the whole work. You spend a whole week on it and you get 2 hours points on appeal. So no, I'm afraid, some cases don't have merit, but unless you can properly look at it and you're properly funded, you're not going to know. And the system is very much against doing appeals at the moment, and I'm sure there are cases sitting there languishing. We get letters all the time and you feel like, oh, I wish I was rich and I wish I could employ 100 people and all of these things. But the reality is that appeals, and they're very narrow, what we decide. We had an inquest, for example, in the Kahui case. The coroner did find that it was the father who was responsible for the deaths. He had gone through the court system and been acquitted. So again, this brings into that whole thing about getting somebody independent with more powers of investigation, the ability to hire people to look at things wider, and of course Mr. Kahui was cross-examined relentlessly by certain people in that sort of situation. So to get an independent body, the appeal system's not working now. There's no money for it, and lawyers just cannot afford to do it. We would love to be able to take on a case. We only have room for one. If you do 40 hours work a week and you get paid 2 hours, next week you do another 40 hours, get paid 2 hours. Doesn't take long to say, well, what am I doing? I'm going bankrupt. I can't afford it.
Peter, do you agree with what Marie just said? I mean, the government recently decreased the legal aid funding. Do you think that was the right choice, or do you think more resources should be put into legal aid?
Certainly in cases like this, there should be more legal aid available. I think perhaps it's the way in which we ration legal aid seems to be somewhat wrong-headed. I'm familiar with a case a while ago that the trust ended up taking involving the Privacy Commission that must have consumed enormous legal resources funded by the state. And it seems an injustice that someone who, this gentleman had been convicted, and he was quite clearly guilty of what he'd been convicted of, and was taking a case against us because we revealed that fact some years down the road, and yet there was no resource available to address cases of genuine wrongful conviction. As Marie says, something's wrong there. We need to re-look at the way, not just the pool of legal aid resource that we've got, but how we're spreading it around, where it's going to. It's obviously going to the wrong places.
Right.
No.
Yeah, no, go for it.
So if you haven't got legal aid available to you, prisoners in New Zealand are allowed access to a computer with which to turn around and file their own, try to build their own case. And that sounds good when you're talking about people like Arthur Taylor, who are quite sharp, but the vast majority of people in prison are not well educated. They haven't got your education, as most of you university students here. In fact, some of them barely left school. Some of them are illiterate. So this means that they're the ability to be able to mount their own case. And if one of you came to me and said, oh my God, something's happened, I've got to go to court, I'm going to defend myself, I'd be going, no, 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 no. Pay someone. Because it's just not a wise thing to do, even for smart people. But if you can't read and you can't write, it's not only hard to do, it's impossible to do. And I think that's something that's a very sobering thought, because you can have a number of people in prison that really haven't got the option, at all, because of this.
Absolutely, no. I think I definitely agree with that. In the interest of time, I think we do have to move on to the next question. It's probably the most significant question to now. It's the issue of how we actually address all these shortcomings that we have identified in the justice system. There has been limitations from the prosecution to the conviction to the appeal process. Now, Jacinda proposed a criminal cases review commission. It was successful in Scotland, it was successful in the UK. What are your thoughts individually on how an independent criminal cases review commission will play out in New Zealand? Will it actually reduce miscarriages of justice?
Can I just say on that, I think it's a very exciting inquiry to make, and Mr. Ardern is clearly well briefed on the various merits of the Scottish and English system. The Scottish one is interesting because they have a similar population size to New Zealand, and apparently it costs about £1.5 million, I think it might be. But look, one of these miscarriage cases would have paid for that to exist. And so it's really quite sad that we can't push the resources into something independent where prisoners can feel that they're getting a fair crack of the whip. They may only need an inquiry or two to be made on their behalf that they feel quite strongly about, and if that inquiry can be made they may then be happy with the result, whichever way it falls. But if it can be done by an independent group who also have access to the police records and investigators and scientists and all of the various things which on their own can be individually not that much money, but to try and get a lawyer to then go and get pre-approval for legal aid and then get a scientist who can, let's face it, earn more money doing other things to beg them and bend a deed to do it at legal aid rate. It is all time consuming and quite difficult, and if an independent body could do that, I have no doubt that that would reaffirm people's confidence in the system of justice, and it would be a strong feeling from the public as well. I'm quite sure that they could then be more confident in our appellate system as a whole, because they would know that that avenue had been explored and investigated quite properly on a person's behalf. And I think in each of the cases that we're talking about today, it would have, as Jacinda said about the Pora case, it would have meant the difference of about 5 years, which is a considerable amount of time for anyone to spend in jail unnecessarily.
I'd just like to pose this question to the rest of the panel. How do you answer to National's claim that we have a really robust justice system, that actually an independent review commission will just replicate the royal prerogative that is already in place, and this will undermine people's confidence in the appellate courts that we have already? Shouldn't we use these existing resources?
We don't have the resources, that's our problem. By making these general statements and that will assay the concerns of people who don't really know what is going on, and it's got nothing to do with where you fit in. There are many people who come from good families who have had the experience of the justice system, who definitely changed their views. We are presupposing we have a system that provides resources, that provides independence, and it's working. So take all that away and you're back to square one. It just simply does not exist. So it's just patter.
Make sure we
and
play that
with nothing in reality.
Yeah,
yes.
play that to John Key and Amy Adams.
Yes.
We'll disagree.
Okay, well, a couple of things really. In regards to that, if you've got a system where you have an independent review, then when something goes wrong, you know it's going to an independent review. So you trust that independent review. If it's not independent, then straight away you start thinking someone's starting to whitewash things. So having an independent review would be very, very good for the legitimacy of the criminal justice system. But what it would do actually, which is probably what's more to the case, is it would actually erode the authority of individual judges that have got it wrong. Yeah, so that's where I think the true resistance is, in all fairness. Now let's talk about independence, because that's the big nub here. If you're going to do this, which nominally I think is a good idea, and it's a good idea because you could even be proactive and go looking for unsafe convictions, which I think would be very important. The problem is what is independence? Well, you know, if you're going to put a judge running it, like you've got running the Independent Police Complaints Authority, well, that's a member of the criminal justice system, no matter how good David is, yeah? That's not independence, yeah? And that's easy, so you turn around and you get yourself a criminal rights, human rights lawyer or a human rights activist at the top with human rights lawyers, and you go looking, and you do your job. That looks more independent. But then you've got to send people out to do some investigations on various different things. Now, who's trained to investigate in this country then? Oh, that would be the police. So you can't have the police go in there, but who else are you going to have that's trained to do the job? Yeah, and here comes the rub. You could go to customs and excise people, for instance. Some of them have the skills to do this. I guess you could find yourself a situation where you actually just train people to do that job for that organisation. But you see, with an organisation like this, while it's nominally a good idea, the devil is actually in the detail. If it isn't truly independent, you'll just have people going, nah, guy heading it up's a judge, don't trust him. Yeah? And rightly so. You need that distance, and it's got to be independent. We don't have an independent police complaints authority at the moment. We have a kind of half and half thing. Yeah? And not even that, actually, in all fairness. So when people are talking about this, we've got to work out exactly what it is that is independent, and how do you go about that, and how do you maintain it? Which act does it belong to? And who can manipulate that act in the future to turn around and remove it? All of these types of things. An independent commission of any kind needs to be able to resist the attempts from the criminal justice system at every level to actually put it in and get it to do what it wants to do. Yeah? Because there will be politics involved in this. Okay? So it needs to be very strong in that way. And it needs to have legislation that makes sure that it can, for instance, compel the police to do something different, or compel judges to do something different. If you haven't got that, if it's got no teeth, it can be as independent as it wants and everyone just ignores it. Yeah, so that's my saying on this.
Thank you, John. Peter?
Yeah, yes, I would like to see an independent criminal review commission, because it would improve the standard of justice. And the key word is independent, as John says. It really has to be truly independent. Possibly one way of achieving this might be to employ people brought in from overseas, from, you know, from the UK or Australia, who don't have a who aren't tied up with our system here, who haven't risen up from that system, who don't have a what's the word I'm looking for? Who don't have a stake in the system as it stands now. And by bringing immigrants to run such a commission, that, or work in such a commission, that might be a possible way of achieving that independence. That's just a possible thought anyway. But yeah, I would like to see that happen, because we need something beyond the criminal justice system to review the decisions of that system and make sure that they truly are safe convictions and sound convictions to increase the confidence of the public in the system. Thank you.
And that's great that you guys, you're all very unanimous in that question. Research shows that in Scotland, where they actually implemented the Independent Review Commission, it resulted in 4 wrongful convictions being overturned every year, compared to just 1 in every 2 years in New Zealand. So you may very well be right. Give that to John. All right, thank you all so much for listening. That concludes the last question of our panel question and answer format. We'll now just allow 5 minutes and we'll open up to the floor. Do you have any questions? And I just advise you to please keep your questions relatively general instead of specific to each case, as there are obviously confidentiality aspects in each case for the lawyers. Does anyone have a question?
Doesn't disclosure work 2 ways?
Yes.
Not if you believe in the presumption of innocence, and it's for the Crown to prove each and every case against you. So the answer to that is no.
Second question I've got is that is the evidence that's often ruled inadmissible, that surely everybody should hear the same evidence. I feel I'm just in a situation where some evidence is not allowed to be shown out because it might have a prejudicial thing, and yet at the end of the day it could have a really good bearing on the case.
I think that's where judges decide, based on the law and each individual case, that if certain evidence was allowed in, whilst it might have a bearing, it would actually be a prejudicial bearing. It's not relevant to a case, and it might end up with juries being wrongfully influenced as to what they should be deciding, what they shouldn't. So decisions are made, and quite properly so, by judges.
Sometimes.
You're not always, of course.
No? Thank you. Does anyone? Yes?
Kind of going the other way, what is the main thing you think could be done to make sure that fewer genuinely guilty people get away with what they've done?
The police would have to catch them. I'm sure you're genuinely guilty of something.
There was something I wanted to mention tonight, and I'm conscious again of you being lawyers, that there's a thing called the prosecution guidelines, and I, as a prosecutor, read them all the time and was a bit anal about applying them constantly to cases. But they're wonderful things, really, and they're very similar. In fact, the ones in New Zealand are identical to the prosecution guidelines in the UK. But they set out the guidelines for when you decide to prosecute a case or not. And one of the points is that not every case needs to be prosecuted, not every crime needs to be prosecuted. And so there is constantly judgments being made about whether the evidential test is satisfied, whether the public interest test is satisfied in the prosecution of a case. And those are important questions to try and have a little bit, try and have consistency. Of course, you know, at the end of the day, this is a subjective exercise. And it may be that the evidence that the police officer thinks is sufficient simply, on the lawyer's view, is not sufficient, and in those cases shouldn't go ahead because they're a waste of the court's time and the state's money, really. And so that question about it's genuinely guilty, there has to be evidence, and it has to be in the public interest before they're prosecuted.
Thank you. Yes.
Okay, I'm not a lawyer, I'm a computer science and mathematics graduate, came along. I'm curious to know about this process whereby scientists can testify for the legal aid rates, because I'd be happy to be involved in IT related. No, seriously.
You don't know what the legal aid rates are.
Yeah, talk to Anna Sandyford, she's your contact. Anna. I'll just explain for everybody in the room.
I did see pick up on a mistake that was made. I read about the David Bain case, yes. I picked up on a mistake that was made in the examination of the computer by the original witness, but I mean others picked up on it as well. I did notice that.
In the Lundy case or in the
in the
Bain case?
I mean, it was,
same
it
witness.
Was noticed that
same expert. It was the same expert in the Bain case and in the Lundy case.
Yes, Brian Cox.
Oh no. Mr. Kleincheese.
No, sorry, it's just in the papers.
Okay.
I did note, I was reading about it, but getting it briefly years ago, with the examination of the computer. I did, where the original programmer had made a mistake regarding the dates on the files. I knew enough at the time to realise that before I read further on that another programmer had discovered it as well.
Thank you. Andrew, you had a question?
So there used to be a maxim that went along with the presumption of innocence that for one innocent person to be put away as guilty, that was much worse than having 5 guilty people walk on the street. Do you think that's a presumption that still applies, A, to the New Zealand, or something the New Zealand public believes, and B, that the government and the Crown believes?
I think it depends on what hat you're wearing, I'm certainly a defence lawyer. That's my bias, my bent, and that's my whole sort of thrust. I think we just have to go back. We've got to get a system where both sides are properly represented. Because I think when you look at prosecution, you are actually looking not just at the police, you're looking at people who are alleging crime has been, against me and I'm hurt. So society needs both sides to be fairly and properly represented and the rules really strictly adhered to. So I think it goes both ways. I think you've got to have prosecution funded properly and obeying the rules, defence properly funded and obeying the rules. So I think that's a trite thing. I think justice has to be fair as it can be.
Thank you, Raihan.
To what extent do you guys agree with Jacinda's proposition that miscarriages of justice extend far beyond the final verdict and that they also relate to issues of accessibility and cost and whether the area from affects the outcome of your trial?
Well, we'd all agree with what Jacinda said, and it was very exciting to hear the fact that a politician has recognised that those are all important elements in trials, because often the issues of cost mean that politicians think that legal aid and issues of criminal justice aren't very important, and that the voters out there don't really care. Perhaps going back to that point, that people don't really care that much about criminals, or care enough, and so they don't want a lot of money to be spent when they would rather it's spent in a hospital. And those are important decisions for politicians to make. But the bigger point here is that more money is being, if you like, wasted trying to fix things that go wrong, when if we could try to get it right in the first place, we could hopefully try to avoid those problems.
Just allow one last question, yes.
Do you think there's any danger in sort of having an adversarial system where the sort of the ability of the lawyers has a huge bearing on the outcome?
Oh, I wish we were that influential. I believe in the adversarial system, because if you say, you know, we're going to have an inquisitorial, we're going to come back and say, well, who's going to be the decider? Who's going to run the show? And I know that when I go to overseas seminars and so forth, that the countries that do not have jury trials and adversarial system just implore you, never lose it, don't have it. So I think adversarial, a fair adversarial, well-balanced, well-matched adversarial, I represent the interests of an accused person, someone else will represent a complainant on the other side, and that's how it should be. But inquisitorial, I'm afraid, who are you going to pick? Who are you going to pick to be the judges? They usually come from a fairly conservative group, and they're going to be split as to where their interests lie. That's my view.
Yeah, I sometimes do wonder myself whether we shouldn't have an inquisitorial system. For one reason, if you have an adversarial system and you have someone who's been raped, the person that's defending the person who's supposedly a rapist, the alleged rapist, is pretty much going to have to victim blame. They're going to have to attack that person's credibility with the usual sexist tripe of, you know, oh my God, you were asking for it rubbish. Yeah. Whereas if you had an inquisitorial system, you're just trying to find out what's going on, and you could probably circumvent a lot of that. Yeah. So there are some things I think where an inquisitorial system would be really, really good. But an inquisitorial system is also very, very open to corruption, because the inquisitorial system that I'm quite familiar with is the Indonesian one, where really you go there, you pay your money and you walk out. Okay, so it's a bit harder to do that if you pay a judge in an adversarial system, yeah, and the jury still turns around and says you're guilty. There's really not much he can do. You know, he's still got to pass some kind of sentence on you. So, in some ways, the adversarial system is more robust, and in other ways, not so, I guess.
Right. Thank you all so much, and thank you all for your questions. I'd just like to invite Marie back up here. Before we conclude the symposium, we'd just like to extend a very warm appreciation to the speakers tonight for taking time out of your extremely busy schedules to come to the symposium. We really appreciate it. You've added really valuable insight to the discussion, and I'm sure that we've all learned a little bit more about our justice system today. So we have just prepared some small gifts for you.
So I've just realised I'm a little bit trapped in some bit of an awkward position. But yeah, just while Joy's handing those out, I just want to say thanks again to everyone so much for coming out tonight. I know that our panel could definitely talk for hours about this, so it's really a shame to cut it short, but obviously we've got lives to get home to. Just like to thank our outreach team, our volunteers who have done amazing work behind the scenes, writing up a symposium paper, preparing just general organisational stuff. I mean, it's like we couldn't have pulled this off without you. Special mention to Sebastian and Jason of the communications team, who are responsible for all the beautiful infographics and PowerPoints and all the social media push behind getting this sort of stuff out there. We do have drinks and nibbles afterwards. If you want to stick around, we'd really love to continue the conversation a little bit longer. And just another reminder that we are a student-run pro bono organisation. We have got hard buckets floating around, but just to end it all, we'd just like to extend a massive thank you to our speakers. Just massive round of applause for them.